Welcome, everyone. I'm glad you're here. Today, we're going to be talking about estate planning. Why are we talking about estate planning now? After all, it could be argued that estate planning is nothing new. It's been around since the laws governing property ownership were created. We take those laws for granted today, but they're critical. They protect your right to own specific property and not worry about someone else, your neighbor, or the government taking it away. When we have ownership rights, depending upon the property type, you can enjoy it for your use, sell it, or give it away. Then, when you die, ownership will be transferred to another individual or entity according to the laws of succession. For example, to a spouse or to a child. Then that person has full ownership rights. The laws of succession governing transfer of property at death are clear and specific, even though we may not always know what they are. For example, in some states, everything one spouse owns automatically goes to another. In other states, it's split between the spouse and the children. So, estate planning starts with knowing the laws of your own state. Then you can decide if you want to take the laws into your own hands, so to speak, by drafting a will or a trust to name the people you want to receive your property after you die. But estate planning involves so much more than just wills and trusts. How you hold title to property in the first place can have repercussions both while you're alive and after you die. Think about your IRA. Most people sign their IRA beneficiary designation forms without even considering it. Still, these forms are powerful estate planning tools that need to be coordinated with the rest of your estate. The point here is that the laws governing property ownership and property transfer are very complicated, and you need to know how they would affect you and your family if you died tomorrow. If you want to override these laws in some way, which most people do to make things easier on their family, you must get the proper legal documents drawn up. We call this getting your affairs in order. Everyone needs to do this because, now remember, what we cover in today's presentation is not legal advice. Please speak to an estate planning attorney for more details. Also, I've attached some notes in the description section for you to follow along with or refer to after the presentation. And don't worry, you don't need to give me your email address to access the notes, okay? If we've learned anything from the coronavirus, anything can happen to anyone at any time. Even regularly, the news is filled with stories about accidents, natural disasters, and sudden illnesses, and other unexpected events that end people's lives. You just never know. And then there's the biggest mystery of all, the fact that death is very predictable. None of us are getting out of here alive, folks, but the timing is usually unpredictable. That's why we need to get our affairs in order now, so we'll be ready when it does happen. Because the laws governing property ownership and transfer are intangible, it's easy to ignore them. But death is a legal event, folks. Once a person dies, these laws come into play and determine what will happen to your assets and your possessions. That is, who the new legal owners will be. If you have done your estate planning, you can live the rest of your life knowing that when the time comes, your loved ones will have the law on their side because you set it up that way. And because estate planning is so important, I'd like to spend a few minutes discussing what could if there is no estate plan in place. If you're unfamiliar with some of the laws that could affect you and your family, this could be a real wake-up call. Let's say you got into a car accident or had a stroke and couldn't communicate with your medical personnel about your treatment options. Wouldn't you want someone to be able to make medical decisions on your behalf? That's what a healthcare proxy does. It allows you to name someone you know and who cares about you to give instructions and permission to medical personnel if you can't. This is often the first part of estate planning because it's the easiest to implement. Your doctor may even have this form for you, so put this on your list and get it done. While we're thinking about the possibility of becoming incapacitated, I promise you, once you have these documents signed, you won't have to worry about it anymore. Also consider your financial and business dealings. Who would pay your bills? Who would transact business? If there's no power of attorney, no one would. This is another thing that's easy to cross off your list. Sign a power of attorney appointing someone you trust to manage your finances if you cannot do so. Take a moment right now and think about what would happen if you died tomorrow. Would your family know what to do first? Would they know who to call? Would they know where your important papers are? Do you have any pets that need to be taken care of? What about your social media presence? Would they know what kind of funeral arrangements you want? Death of a loved one is always shocking to the family, but you can make it easier on them by writing out a letter of instructions. It doesn't have to be a formal or legal document. Still, it's an essential part of estate planning because it expresses your wishes about miscellaneous things, and it may even include expressions of love or gratitude. Heck, you can even make it a video. Laws governing property ownership and property transfer are meant for your protection. After all, after your death, your assets will freeze, so others can't take them before everything is sorted out. Depending upon how your accounts are titled and what other estate planning measures you have in place, this could mean the people closest to you cannot access assets until the law says they can. Worst case, your surviving spouse wouldn't even be able to get money out of an ATM. But let's say you have your money in a joint account and your surviving spouse's immediate cash needs are met. What about their ongoing needs? Will your surviving spouse have enough assets to carry on and live comfortably? Will those assets be positioned to generate sufficient income for the rest of their life? Keep in mind that for married couples, estate planning needs to span 2 lives. Those succession laws we discussed will kick in and decide who gets your property after you die. Instead, what will happen if you don't intervene and effectively override those laws? Here's a chilling example for you. When singer Barry White died in 2003, he was separated, but not divorced from his second wife. Now, in the eyes of the law, he was still married. So, his ex-wife got everything. His live-in girlfriend for several years and their children received nothing. This is why estate planning begins with basic knowledge of the law. Who would get your property if you died tomorrow? Even if your situation isn't as drastic as Barry White's, you may want to finesse the distribution of your assets. Maybe you want some to go to your grandchildren. Perhaps you have a friend or non-relative to whom you'd like to leave some money. Maybe you have charities you'd like to continue to support after your death. There's so many ways to design an estate that nearly all improve upon the laws of succession as your state legislators have written them. The current estate tax exemption is over $12 million, $24 million for couples. People have gotten a little complacent about estate taxes, and that's true. If you died tomorrow and your assets totaled less than the exemption, there'd be no estate taxes. But there are 2 things you need to know about this. First, the exemption amounts are scheduled to go back down to $5 million, $10 million for couples in 2026. If you continue procrastinating and Congress doesn't extend the current exemption amounts, your estate could be subject to estate taxes. The other thing is that estate taxes are not the only taxes to worry about. Some states impose their own estate taxes with lower exemption amounts. Some states even impose inheritance taxes on your heirs. Also, if you pass on an IRA, your beneficiaries may have to pay income taxes on the distributions. These taxes usually can't be avoided, but they can be reduced or deferred if managed correctly. Another big part of estate planning is preparing your beneficiaries for their new responsibilities. Will they know how and when to take the RMDs from their inherited IRAs? Will they know how to manage this new pool of assets? Traditionally, estate planning was done in secret. This was partly because no family wanted to talk about death. It's also because the patriarch or the matriarch didn't want to start any family squabbles. It was better just to let those things happen after we're gone, right? But today's modern form of estate planning is far more transparent. Parents want to help their children. Adult children often know how much of an inheritance they can expect to receive, which allows them to prepare for it. At the very least, you can introduce your children to your financial advisor so we can start working together. Then, when the time comes, your children will have somewhere to turn, and we can help them with the air, and we can help them with their RMDs and other things. Okay, let's say you already have an estate plan in place. You've seen a lawyer and had all the necessary documents drawn up. It feels good now, doesn't it? I can tell you from experience that my clients who have done their estate plans feel like a weight has been lifted from their shoulders. They know their affairs are in order and their wishes will be fulfilled after they're gone. If that's you, congratulations. Now, I have to tell you that the job is never truly all done. As you move through life, your financial situation and family composition changes. Your estate plan needs to be updated. We talked about the sad situation of Barry White, whose ex-wife inherited his estate to the exclusion of his live-in girlfriend and children. There's also the story of Heath Ledger, whose 2-year-old daughter was left out of his will because he never updated it after she was born. Instead, everything went to his parents and sisters. This story does have a happy ending because Heath Ledger's family gave all the money to Ledger's daughter. But we all know that not all families are quite so fair-minded, right? Also, sometimes people do their estate plans but fail to finish the job. Consider Michael Jackson, who created a revocable living trust to transfer his wealth to his children and his mother after he had passed, but never funded the trust. Instead, his entire estate was left outside the trust. The estate had to go through the probate process while Jackson's children and mother lived off an allowance managed by the estate's executor and a judge. It went on for years. During the probate process, the estate faced numerous legal challenges from creditors and Jackson's own family. Let's look at some situations that may call for updating your estate plan. How much has your house appreciated since you created your estate plan? How about your retirement accounts? Even if you're still under the federal estate exemption amount, an increase in assets could require different strategies, tools, and decisions about who will get what. Or you may have fewer assets than you once had due to portfolio withdrawals or investment losses. Reduced assets may call for different plans as well. Maybe you're not feeling quite as generous as you once did. Perhaps a gifting program you had set up is a little unaffordable today. Remember, estate planning is not just about transferring assets after your death. It's about ensuring a lifetime income for yourself and your spouse. Maybe you want to revisit your estate plan if your assets have risen or fallen in value. Children do grow up. That minor child you provided for in your will may now be well past the age of majority. Those young adults you once thought couldn't handle a large pool of assets may be all grown up and capable of handling an inheritance. Or maybe your adult children are in a place where they could use part of their inheritance now. If they need money for a house or to start a business, and if you can afford it, why not help them out? Lifetime distributions are also a part of estate planning, and you get the satisfaction of seeing your money put to work by the people that you love. Has your family had wedding bells since you last did your estate plan? Have you welcomed a new son or daughter-in-law? This new union also has legal ramifications concerning your daughter or son's inheritance. Even if you have openly welcomed a new family member and are happy to share your wealth, your child's new marital status requires a fresh look at your estate plan. The birth of a child always requires an estate plan update. Even if your will or trust was written to include the grandchild not yet born, as not to disinherit them intentionally, you'll want to bring your documents up to date to name the new child and make other necessary revisions. Now, if you've recently divorced or remarried and haven't updated your estate plan, it's time to excuse yourself from the presentation and go call your attorney. This is one of the biggest estate planning blunders I see, keeping an ex-spouse as a beneficiary on a life insurance policy, retirement plan, or even a will or trust. People who have gone through a divorce usually are so tired of dealing with attorneys that they put off updating their plan, figuring they'll take a little break and we'll get back to it later. Then they never get around to it. It's tragic. Or what if you have a new spouse? This new union brings legal consequences. If you have children from a former marriage, You'll want to balance everyone's needs to ensure that your estate plan documents reflect that. Now, I'm not telling you how you should plan your estate. Some of these decisions can be extremely complicated. I'm just here to remind you that if you don't update your estate plan following certain legal events such as a divorce or remarriage, disaster could ensue. Proactivity is what we like. If you haven't made a move yet but are thinking about divorcing your current spouse and or remarrying a new spouse, please put estate planning front and center. Until you're divorced, remember, until you're divorced, you're considered married in the eyes of the law because it may be difficult or impossible to remove a soon to be ex from certain accounts while you're going through a divorce. And because specific estate planning changes can complicate the divorce proceedings, you need to consult both your divorce attorney and your estate planning attorney. If you're thinking of remarrying, you may be advised to get a prenup. Now, I know people have differing opinions about these, so I'll just put it out there and let you and your lawyer decide what is best for you. Yes, they have. Taxes may have changed several times since you last did your estate plan. Unless you are an estate planning attorney, you may not know which laws might affect your estate plan. Most good lawyers stay in touch with their clients and notify them when their estate plan needs to be reviewed in the light of law changes. But maybe the lawyer who did your estate plan hasn't kept in touch. Or perhaps they did and you ignored the communication. Whatever. It's tough for ordinary people to keep up with the changes in tax laws. For one, you're getting your information from the news, and there can be confusion over which laws have passed and which laws have been proposed. Among the past laws, it's sometimes unclear what the effective dates are, and some laws are so complicated and arcane that ordinary people simply can't understand their effect. So, for example, the laws governing all the different types of trusts are nearly impossible to know without a deep understanding of how those laws work in the first place. One of those trusts could now be perfect for your circumstances, but you'd never know without an estate planning review. I'll just say if it's been a couple years since you've reviewed your estate plan, it's probably time. As politicians come and go, we can count on new legislation every so often to undo the last round of changes. Also, because many of our laws are due to sunset at a specific time, we know the laws are going to change. We don't know if Congress will allow the laws to sunset, which means things could go back to the way they were before, or if it will pass different legislation before the sunset occurs. All we know is that things will be different in the future. Estate planning lawyers have their work cut out for them to draft documentation. Estate planning lawyers have their work cut out for them trying to draft documents to accommodate changing laws when they really don't know what the new laws are going to be just yet. However, frequent reviews and revisions can help you stay on top. And remember, what matters is what the laws are in effect when you die, not when your documents are created. Many of the laws governing estate planning are state laws. Now, some estate planning documents can carry over from state to state. However, some need to be drafted anew to comply with the new state's requirements. And there might be some laws in the new state that point to a different strategy. The bottom line is that if you have moved to a different state since your estate plan was done, make an appointment with an attorney in your new home state for a thorough review of your estate plan. Now, you're not going to be around to watch, but your executor and successor trustee will be very busy after you die, rounding up all your assets, accounting for everything, and eventually distributing them to your chosen beneficiary. While you're alive, you'll want to keep tabs on these people. Presumably, you've chosen someone close to you to whom you trust implicitly. It could be an adult child, a family friend, or a trusted professional, preferably someone younger than you. You may have also named a successor executor or trustee if the first person isn't available. Keep tabs on these people too. If you discover that the person or people you called cannot administer your will or trust, you'll need to name someone else. Hey, this happens. People put off doing their estate planning because they can't precisely decide whom they want to inherit their assets. Hey, it's okay. These can be hard decisions, but it's better to take a stab at it than not have an estate plan at all. Your will or your trust can constantly be revised if you change your mind. If you've forgotten who you named beneficiaries, it's time for you to update your plan. Pull out the documents and read what's there. Is that what you really wanted? Is that what you still want? Have you changed your mind about anything, especially in light of the things we've discussed, like a new family member or a change in marital status? So, if it's time to update your plan, preparedness is an antidote to fear. This is a famous quote that applies to many areas of life. Some people fear death because they worry about what will become of their loved ones after they're gone. Your family will miss you, of course, but with a solid estate plan in place, at least they won't have to wonder about what you would have wanted and can ensure your wishes have been fulfilled. Your estate plan may be about stating your wishes, but you're also doing it for them. Taking the time and trouble to get your affairs in order is one of the most loving things you can do on this earth. Now, I hope this presentation has opened your eyes to some of the issues surrounding estate planning. I'd love for you to make an appointment to sit down for us to help you determine what you need. We have an estate planning assessment that's simple and quick, and you can access the link to my calendar down in the description. Once we have determined what you need, we can make a plan to check off the items that need to get done, whether it's organizing your records or meeting with an estate planning attorney. Whether you're doing your estate plan for the first time or have questions about your existing plan, I'd love to help. Thank you all for joining me today, and I hope you take advantage of the free consultation.